I have a few follow-up issues for you on redirect. At the beginning of your cross-examination, before the attorneys began to cross-examine you, Mr. Challey made a point in the context of an objection, and I would just want to mention that point to you. He pointed out that you're not an expert who has only reviewed documents and depositions here, that you also have firsthand knowledge of some of the events on which you offer opinions. Now, is that a true statement, that you actually have firsthand knowledge of some of the events that you're talking about in your testimony?
Yes.
And are you sitting here today to have your credibility assessed by the Commission with respect to your recitation of the facts regarding those events?
So I don't fully understand that. If you're, I'm here to testify as a recognized expert engaged by ORS to monitor the construction and cost, and that was part of my duties. So I'm not here only to testify relative to the facts that were presented subsequent to the case.
And have you actually reviewed the documents and depositions that were attached to your testimony in this case?
Yes, sir.
And are your opinions based in part on the documents you reviewed as well as the facts that you know from being at the project?
Yes.
I'd like to turn, Mr. Jones, to the issue about your efforts to obtain the results of the Bechtel assessment. Do you feel that you did anything wrong by accepting SE&G's word that the Bechtel assessment did not reveal anything new on two separate occasions?
No, sir, I do not.
These employees who provided this information to you that the assessment did not reveal anything new, were these low-level SE&G employees?
No, sir.
What were their roles on the project, to your knowledge?
I think Mr. Skip Smith was the business and finance lead on the project. I don't remember his exact title, but he was the #1 business and finance lead on at the site on the project. Alan Torres, who I talked with, was a construction manager, and Kyle was his immediate. Kyle reported to him directly. And Shirley, I don't remember what her title was, but she worked with directly under Skip, I think.
Mr. Jones, sitting here now and based on your own personal experience on the project, do you believe that if you had just asked one more time for any report from the Bechtel assessment, that would have just done the trick and SE&G would have immediately handed you a copy of the Bechtel report?
No, I don't believe that to be the case, and I think that's supported by the record of how they tried to hide and conceal the Bechtel report.
Mr. Jones, now that you've seen the Bechtel reports and know what is in them, do you believe that ORS should have even had to ask repeatedly to get the reports?
No, sir.
Did ORS have the power to issue a subpoena to order the reports produced in 2016?
Well, you're going a little bit beyond my expertise, but my understanding is we did not have subpoena power at that time.
Now, Mr. Jones, let's turn to this discovery request that ORS sent, the Air 1-32 that Mr. Challey spent a fair amount of time questioning you about. I'd like to first look at SE&G's response that's in your testimony, and we'll pull it up on the screen here. It's Exhibit GCJ 2-52. And I'd like to have you look at the response that's provided by SE&G. Specifically, the first question, what can you tell from this document as far as how many times SE&G responded to this request?
Well, if you're talking about just what's on this page, there was an initial response, first supplemental response, second supplemental response, which means 3 times.
So I'd like to now show you a document that's dated March 24th, 2016. Mr. Chairman, may I approach the witness? Mr. Jones, can you identify what this document is?
These are SCE&G's responses to our AIRs.
And did you receive a copy of this document from SCE&G?
Oh, yes.
Mr. Chairman, I would move to have this document, SCE&G's response to ORS AIRs dated March 24th, 2016, entered as the next hearing exhibit.
This document will be entered as hearing exhibit number 28.
I'd like for you to turn now to the response to AIR 1-32, Mr. Jones. The pages aren't numbered, and Larry will bring the page up on the screen as well.
All right.
This request that ORS sent to SCE&G, does the request use the term amendment anywhere in the request?
No, sir.
And what does it refer to instead of an amendment?
The agreement.
Do the other request, if you could turn actually to the second page of the document, request 1-1, is the term amendment a defined term on that page?
I'm sorry, I'm not really following what you're asking there.
Sure. If you look at request 1-1, part A, do you see where it refers to October 2015 amendment?
Yes. Okay.
And does it then define that term as the term amendment?
Yes.
Now, I'd like for you now, Mr. Jones, let's go ahead and assume that SCE&G did believe that request 1-32 referred only to an amendment. I'd like to turn to one of the documents that's in Exhibit 12 of your Sir rebuttal testimony. And it's an email exchange. $289. It's 289, page 102.
I'll remind you, we do have Elmo right over there. It's a little older tech, but it works pretty quick.
All right. Thank you, Mr. Chairman. I might do that.
Mr. Erskine's coming to the rescue.
Switch back. I found it.
Well, maybe Elmo's not faster. My grandson loves Elmo.
I can go Elmo. I can go Elmo now. Thanks. Okay, thank you. So, Mr. Jones, this is an email exchange from your Sir Rebuttal Exhibit 12, and at the bottom of this page, beginning the email exchange, it's an email from Belton Ziegler to Abney Skip Smith, dated October 28th, 2015. Why don't we go ahead and use the Elmo? I'm sorry. Thanks. So this is in your Sir Rebuttal Exhibit 12, Mr. Jones, an email exchange beginning an email from Belton Ziegler to Abney Skip Smith. Subject is settlement with WEC, and the date is October 28, 2015. And you recall that date, October 28, 2015, Mr. Jones, as far as what was occurring at that point in time?
That was, the thing I recall is we had our regularly scheduled meetings on October 27th and 28th of 2015 with regularly scheduled status meetings with SC, E, and G.
Do you recall that being as the time when the 2015 amendment between Westinghouse and SC and G was executed as well?
It's in that same time frame. They'd come to agreement, I believe, on the amendment before that date, and I think the official date for signing was shortly around this time period.
So the email states, quote, "I noticed discussion of owner's consultant. Has a consultant been hired? Is this something we need to disclose now, or should we wait? I think it is a positive and sounds best as part of a general restructuring of relationships, not a follow-on later." And Mr. Smith responds that same day, 2:30 p.m., to Belton Ziegler and copying Chad Burgess and Byron Henson. Do you know who Byron Henson is, Mr. Jones?
Yes.
Who is he?
I can't say exactly, but he was involved with the project. I think he's primary regulatory liaison or something like that. I don't remember his exact title.
Did you liaison with him as part of your work on the project?
We often met with Mr. Henson, yes.
So Mr. Smith, in response, says, quote, "This applies to Bechtel, who has just completed an analysis of our project and will likely stay involved. Santee has been pushing this. We'll probably never see a written report of the Bechtel study and have not been briefed by senior management on their findings. We are paying a 100% price tag of $1 million for this study. Not sure how to address in BLRA. ORS is aware. You may want to check with Chad and Byron, whom I copied." And then just a minute later, actually, Mr. Ziegler responds, quote, "If it is not our study, then I say we don't mention it." Mr. Smith responds just a few minutes later, "We in Santee contracted the study but through our outside counsel, George Winnick, Al Bynum can give you insight. I would prefer not to mention it. Belton Ziegler responds a few minutes later, quote, if it is attorney-client privilege, then that is also a good reason not to mention it. And the email chain for this document ends with Mr. Smith responding, quote, I believe that's the case. I copied Al for this confirmation. From this email exchange, does it appear to you, Mr. Jones, that Mr. Ziegler, SE&G's attorney, wasn't aware that the Bechtel assessment was privileged?
I mean, I can only go by the words stated there. It sounded as that was the case.
And Mr. Jones, does this email give you an idea of whether SE&G considered Bechtel a consultant under the 2015 amendment to the EPC?
I'm not sure that gives me any insight into that. I mean, they considered them a consultant to the project, but I don't know about the amendment.
So let's go back to that exhibit that you were just provided, Mr. Jones, the first response by SE&G to the ORS discovery request. And that's in the exhibit marked in front of you. Mr. Jones, in litigation, the rules require the parties to notify other parties when they are holding back responsive information based on privilege. Was there anything in this response that SCE&G provided to this request that notified you that there was a report being held back on the grounds of privilege?
No, sir.
And let's go to the cover page of this document as well. And you can look at it in front of you, the first page on this document. Is there anything on this cover sheet that notifies you that SCE&G is withholding information from ORS's request based on privilege grounds?
No.
And who signed this response, Mr. Jones?
Matthew W. Gisendonner.
What was the date on this response?
March 24th, 2016.
Was that date after all of the versions of the written Bechtel report had been issued?
To my knowledge, yes. All the ones that I'm aware of, yes.
So I'd now like to turn forward in time and, Mr. Jones, and show you another document dated June 24th, 2016. Mr. Chairman, may I approach the witness?
Yes. I figure if everybody else can delay a little bit, I can too.
Mr. Jones, can you identify this document for the record?
These are supplemental responses from South Carolina Electric and Gas to ORS audit information request.
Did you receive a copy of this document from SCE&G?
Yes.
Mr. Chairman, I would ask now that this response by SCE&G dated June 24th, 2016 be entered in the record as the next hearing exhibit.
This response will be entered into the record as hearing exhibit number 29.
I'd like for you to turn, Mr. Jones, to the response to AIR 1-32 in this document.
I'm there.
Is there anything in this response that notified you that there was a report being held back on privilege grounds?
No.
And just to be clear, this is a second response to that request by SCE&G, correct?
Correct.
Let's go to the cover page of this document? Is there anything on the cover page that notified you or ORS that there was a document or information being withheld on the grounds of privilege?
No.
And who signed this response, Mr. Jones?
Mr. K. Chad Burgess.
And what is the date on this document again?
June 24th, 2016.
Now, Mr. Jones, turning to the response that you included in your testimony, the second supplemental response, and we'll pull that back up on the screen as well now. Is there anything in this supplemental response that SC&G provided that notified you that there was information being withheld on privilege grounds?
If you blow it up so I can actually see it, I'll make sure that's the case. No, there is not.
So this is three different responses by SC&G to this discovery request by ORS, and none of those responses indicated that information was being withheld on privilege grounds. Is that correct?
Yes.
I'd like to fast forward now, Mr. Jones, to a discovery request that ORS sent to SC&G on May 16, 2018. Mr. Chairman, may I approach the witness?
Yes.
Mr. Jones, can you identify what this document is for the record?
This is an ORS request designated NND request RCT-06, and it's looking for copies of the standalone Bechtel assessment report.
And were you involved in putting these requests together as well?
I think we knew that we wanted to we wanted to request the Bechtel report. I don't think I had any actual involvement in this specific request, but it was something we had all agreed. By that I mean the ORS team that we needed, and so the request was put together.
Mr. Chairman, I would ask that this document, response dated May 16, 2018, be entered as the next hearing exhibit.
Be hearing exhibit number 30.
Now, Mr. Jones, on this response dated May 16, 2018, did SC&G indicate that it was asserting a privilege claim in response to the request for the Bechtel report?
Yes, it so states in their response.
And is it correct to say that SC&G did not notify ORS about a privilege claim regarding the Bechtel report until this request, after the existence of the report had become public?
This is when I became aware they were asserting privilege, other than through public pronouncements that it was privileged.
You mentioned, and that's all I have on that document, Mr. Jones. You mentioned in your testimony that anticipation of litigation didn't make sense as a privilege ground due to the nature of the October 2015 amendment. Can you explain a little bit about that?
Well, the whole basis there is the October amendment to the EPC contract prohibited litigation. So that I could see no reason why they would still maintain, even if this was prepared in preparation for litigation, why they would still make that claim.
Now, Mr. Jones, is there any reason SC&G couldn't notify the Commission or ORS of the existence of the more serious schedule concerns that were identified by Bechtel while not producing the report itself?
It is my understanding that such notification could be made, and claims of confidentiality and privilege could have been made to the Commission and to ORS.
Now, Mr. Jones, I'd like to turn to the PowerPoint slide you used in your introductory summary presentation, specifically the schedule information that you put on there. I think during Mr. Elliott's cross-examination, Mr. Elliott might have unknowingly gave SC&G some credit regarding the schedule dates on here. What I'd like to do is for you to identify which of these series of dates was issued first. The completion dates that you're pointing out in the top column, or the Bechtel completion dates in the second column, or the SC&G completion dates.
Well, I think you have to take into consideration what's formal issue. The WEC completion dates were known about first, or at least known about by us first. So the sequence is as represented here, that the WEC completion dates were identified then at the October 22nd meeting, the Bechtel completion dates, and then the SC&G completion dates were identified in actually I'm in late 2017, I think, and then I actually got them from a report filed later than that, but they were known at that time in late 2017.
I think the question I want to put to you here, Mr. Jones, is were those WEC completion dates on the top column, were those the substantial completion dates that were in effect with the Commission at the time that SCE&G received the results of the Bechtel assessment?
No, they were not in effect at that time. They were part of the filing.
And when did that filing occur?
I'd have to look again at my it was in 2016, but I don't remember exactly when the filing occurred. I'm sorry.
So is it correct to say that SE&G requested the substantial completion dates in the top column after becoming aware of the results of the Bechtel schedule assessment in the second column?
I think that's true relative to the filing. The dates were, I think, known before the filing, but I think that's true relative to the filing.
Now, Mr. Jones, I'd like to turn to a separate issue that you were questioned about on cross-examination, and that's the timing of the Bechtel engagement, when SCE&G and Santee Cooper engaged Bechtel. I'd like to show you an email that was in the Elizabeth Warner exhibit, A1. It's an October 31st, 2014 email by Stephen Byrne, and we're going to bring it up on the chart for you here. This is an email from Stephen Byrne, October 31st, 2014, to Kevin Marsh, Jimmy Addison, Michael Crosby, Mark Cannon, Ron Jones, copy Jeff Archie. Subject is outside look at new nuclear. Quote, we have previously discussed getting a third-party look at our schedule and on-site efficiencies at VC Summer Construction Project. We are trying to find someone with mega project experience. Our previous experience with PricewaterhouseCoopers was not good. NextEra, Florida Power and Light, indicated that they had a similar issue on their extended power update project at St. Lucie and brought in Highbridge to advise. We floated the idea by WEC and CBI on our Friday call, and they did not object. They identified a concern with intellectual property, but thought that it could be worked through. And I'll end quote. I'll stop there. Does this email to you, Mr. Jones, indicate that SC&G was in fact considering a third party, not an individual employee, but a third party to do an assessment that included the schedule in October 2014?
It is so stated, yes.
And this is only a month, or the month after the email that you were shown by Mr. Challey that was authored by Mr. Marsh and that Mr. Marsh discussed in his deposition, correct?
I don't remember the exact dates, but if that's the case, yes.
Now, Mr. Challey also showed you an engagement letter between SC&G's construction attorney, Ann Bechtel, from August 2015. Was it your understanding that SC&G knew the Bechtel assessment would occur even before they papered that deal in August 2015?
It's my understanding that they had made the decision to do that much before the August date, yes.
And I'd like to look at one other document from the Elizabeth Warner exhibit, A5, that relates to that. This is I'm going to zoom in. This is an email from Michael Crosby to Stephen Byrne at SCANA. It says, Steve, I spoke with Craig Albert this afternoon. You remember Craig from the hangar, sat in the middle, President Bechtel Nuclear Security and Environmental, Inc. Craig is aware of where we stand relative to moving forward with the assessment. That is, the owners have board approvals to move, but have not notified the consortium of the, quote, Bechtel selection, end quote, including clearing a path through the consortium CEOs, Roderick and Asherman, end quote. Is this one of the emails that supports your view that the fact of the Bechtel assessment was agreed to before the July 2015 commission hearing?
Yes, it certainly would support that, yes.
Now, I'd like to turn, Mr. Jones, to the actual substance of the Bechtel assessment. You mentioned earlier that that the credibility that SCE&G was assigned to the Bechtel assessment was shown by their indication that they were going to implement the recommendations. Is that fair to say?
Yeah, I think it's one of the indications that they did not think it was a useless assessment, that they tracked the implementation of the Bechtel recommendations.
And Mr. Jones, you were earlier shown by Mr. Challey deposition testimony from Ron Jones where he said that Bechtel circled the bullet holes on the project. Do you recall that?
I remember that, yes.
So is it fair to say, Mr. Jones, that SCE&G views Bechtel as having accurately identified the issues on the project and done a good job of assessing recommendations to address those issues, yet is testifying that it doesn't assign any credibility to the schedule assessment done by Bechtel?
Mr. Chairman, I would object. We've heard a lot from Mr. Jones today on what he understands from certain documents, and I'm not interfering with Mr. Cox's efforts to ask questions about those documents, but in this instance, Mr. Cox is asking Mr. Jones what SCE&G understood in a way that's clearly hearsay and inappropriate in this context. And I would also add, it clearly calls for speculation.
Okay, you want to rephrase that?
I will, Mr. Chairman. Thank you. Mr. Jones, what is your view of what SC&G decided to adopt from the Bechtel assessment and what it is now saying in this proceeding that it found lacking?
Well, I mean, I've seen previous statements by SCE&G that the Bechtel report was useless because it found the issues that they already knew about. Well, my question is, why wouldn't you have that expectation? It should have found issues that you knew about because they were the major issues on the project. It seems to me that's evidence of a good assessment, not evidence of a useless assessment. Furthermore, it provided recommendations, which, at least to our knowledge at that time, recommendations on how to fix these, recommendations that SCE&G had not developed, or at least they had not shared what they were going to do with us. And so, to me, as I've always said, the issues that Bechtel identified were not surprises to me either, but they further validated that these were the top issues on the project. And that had good value. If you have one of the top nuclear constructors in the business come in and identify issues, the fact that you have identified them before is not grounds for making the assessment useless. It's ground for saying, yippee, we kind of know the issues. So then the second part of that is then, okay, how are you going to fix them? To get Bechtel's input on how they're going to be fixed was also extremely valuable because, again, they're one of the premier nuclear constructors in the world. So I would have thought that would have contributed to making the report more than useless. It would have made it very important. And then the last is always the schedule assessment, which to me takes primary importance over all the other stuff. To be able to look at that assessment, and it wasn't just a fly-by-night, pull it out of the air assessment. Mr. Troutman has gone through in his deposition, and there was considerable discussion within the Bechtel report itself of the methodology that they utilized. And again, it's not to develop a schedule by which to construct the project. It was to develop a schedule assessment. And it was could have been very useful to SCE&G to embrace the schedule assessment rather than to hide it.
Mr. Jones, you mentioned Mr. Troutman. Who is more qualified to talk about the quality of Bechtel's schedule assessment, Mr. Troutman or the construction attorney, Mr. Winnick?
I don't think there's any doubt about that, Mr. Troutman.
And why is that?
I don't believe that the engineer has sufficient background to make any judgment about a schedule.
The engineer, you said the engineer?
I meant the lawyer, I'm sorry, the attorney. Sorry.
I'd like to turn to the issue of the internal cost calculations done by SC&G prior to the March 2015 commission docket, the issue raised by Commissioner Williams earlier. I'd like to turn back to Exhibit 28 in front of you, Mr. Jones. That was the March 2000 response by SC&G to the discovery request by ORS. And I'd like for you to turn specifically to request 1-38. And the request 1-38 stated, quote, perform an economic analysis of delay scenarios of 18, 24, 36, and 48 months beyond the forecasted commercial operation dates associated with order number 2015-661 and with the amendment. The delay scenarios should provide estimates for the total project cost as well as the revenue requirements associated with the total project cost that customers may incur both during construction and over the operating lives of the units. Now, SC&G responded to this request, Mr. Jones, stating, quote, SC&G has not prepared any such analyses and does not have information necessary to do so. Such analyses would be highly speculative and would not result in probative information, end quote. This was the response that you received from SC&G in response to this request. Is that correct, Mr. Jones?
Yes.
I'd like to show you an email dated October 6, 2015 from Kevin Kokums. Mr. Chairman, may I? Mr. Jones, have you ever seen this email before?
I do not recall ever seeing this, no.
Mr. Chairman, this is an email produced by SC&G in this litigation. I would request that it be marked as the next hearing exhibit number.
This will be marked as exhibit number 31.
Mr. Chairman, I didn't jump up fast enough. There's, as Mr. Jones just indicated, no foundation for this document whatsoever. Mr. Jones is Mr. Cox's witness, so it can't be used for impeachment purposes. I see no grounds under which this particular document should be entered into the record.
Mr. Chairman, I would respond by pointing out that it's produced by a party opponent. It's self-authenticating. We're not entering it for the truth of the matter asserted.
Okay, we're going to overrule. Continue.
Mr. Jones, in this email, is it correct that SCE&G was using a PF number of 1.75 as its best case scenario for completing costs of construction of the project?
I'm sorry, I don't see that it's indicated as best case. It appears to be what they're using.
Right below the bullet points, it says, quote, for the best case scenario, here are the significant assumptions we made. Did I quote that accurately?
Okay.
And that PF, is that a worse PF than than was used in the 2015 commission filing?
Yes.
What was the PF that was used in the 2015 commission filing?
1.15.
And is it true that, is this PF even worse than the PF that SC&G used in doing its internal calculations prior to the 2015 PSC filing?
I assume there you're referring to the EAC team estimate. And,
Correct.
And my recollection, and this may be off somewhat, but I believe they were at like 154, 155, something like that, something in that range.
Okay. And if you turn to the second page of this document, Mr. Jones, there's a spreadsheet entitled EPC Cost Comparison Between Continuing on Current Path and Moving to a Fixed Price. And the far left column is under a heading entitled Cost Estimate to Continue on Current Path. Do you see that?
Yes.
And then to the far left below that, it says best case scenario. Do you see where that is, Mr. Jones?
Yes.
And in the bottom row, what is the total actual cost to complete?
In that column, it's, well, I'll give you, I assume this is, yes. So it would be $6,806,261,000.
And then moving to the far right set of three columns, under the heading Cost Estimate to Move to Fixed Price, if you look under the green column there, moving to fixed price, best case scenario, June 19 and June 2020, what is the actual cost to complete under the fixed price?
$6 billion is what it states.
And so did SC&G there calculate below that the projected benefit of moving to a fixed price versus the current contract?
As I see the numbers there, they calculated that to be $806,261,000.
Now then, in the far right column, Mr. Jones, SC&G did another calculation using a 12-month delay period, with the units being completed in June 2020 and June 2021. Under that column on the far right, can you see how much of a benefit to SC&G the move to the fixed price would be versus the current contract?
$1,889,021. $889,021,000.
So from your review of this spreadsheet, does it appear that SC&G had calculated that the move to the fixed price option would result in a benefit to SC&G and a loss to Westinghouse of anywhere from $800 million to up to close to $2 billion?
That's what this would indicate to me, yes.
And these dates that SC&G used for the estimate with the close to $2 billion loss, are these dates still more optimistic than the dates that were identified by Bechtel?
Yes.
Is this the kind of information, when you were talking about your position in the 2016 docket, Mr. Jones, and you mentioned wanting to be aware of the Bechtel report and how that would affect the likely burden on Westinghouse, is this the kind of analysis that would have helped you in assessing that issue?
Yes.
And is this the type of analysis that you and ORS were calling for in response to that AIR 1-38?
Yes, it's the type of analysis. I think we requested even more extended completion dates, but this is the type of analysis that we would have been looking for.
And in response to that request, SC&G stated that it had not prepared any such analysis and does not have information necessary to do so, and that such analysis would be highly speculative and would not result in probative information. Is that correct?
That's what they stated.
I'd like to turn to the assessments, the internal assessments done by SCE&G earlier in 2015, prior to the 2015 docket, of which you said you were not aware. I'd like to turn first to a presentation, an internal SCE&G document. It's a presentation that was included in your SIR rebuttal exhibit 12. It's 289-66. So this is an EAC review team preliminary update, preparation for 10/13/14 executive meeting. Do you recall whether you saw this document prior to abandonment, Mr. Jones?
Yes, I recall. I do recall, and we did not.
And I'll turn to the third page of this document. This refers to direct craft productivity. And I'd like to turn to the third bullet point. It says, quote, EAC team anticipates a to-go PF closer to 1.40 and recalculated the cost, resulting in an additional increase of approximately $101 million. This is the cost impact of the to-go PF of 1.40 versus 1.15 and is not included in the consortium EAC. Were you aware of that information at the time that it was issued in 2015?
No.
And there's one other document, Mr. Jones, I'd like to show you from the SCE&G EAC analysis. And it's a report produced by the team and emailed in May 2015. I'd like to turn to a conclusion reached by that team in their final report. Page 100. At the very top of this page, Mr. Jones, the EAC team report says, quote, in its EAC, the consortium assumed that the project would reach a goal PF of 1.15 within 6 months. This does not appear to be achievable. The owner does not believe the assumed to-go PF of 1.15 is achievable with the current CB&I organization. So the EACH review team recalculated the cost with a PF factor of 1.40 to go. Is this what you were referring to earlier when you were asked by Commissioner Williams about documentation that SCE&G had concluded that the consortium's EAC was not achievable?
This is one of the documents, yes.
Mr. Jones, you were also asked about an independent study that ORS had conducted with respect to a presentation that ORS gave. Do you recall whether that study was a nuclear construction study?
I'm sorry, I don't understand that question.
If you could turn to Exhibit 20 in the stack of papers that you have there, up on the table.
What is it?
It's the PowerPoint presentation that ORS conducted in 2016. There you go. Now, Mr. Challey asked you about the study that's referenced on page 5 about an independent study. Basically, the question is, do you recall what the nature of that study was?
My recollection is, and I want to say again, which I think I said before, is that I did not have much participation in this study, but my understanding of what it was that they basically took Dr. Lynch's numbers and kind of reran them to see what the impact would be.
And do you know if that was an accounting study?
I don't even know what you mean by accounting study, but what is that? What are you asking?
Would it refresh your recollection to look at a press release that ORS released about the study? or not?
I don't think it would. I didn't know. ORS pretty much did this, undertook this study on their own, and I had very limited involvement in this. It was primarily just, like I say, to look at different dates based on Dr. Lynch's approach.
Okay, thank you, Mr. Jones. I don't have any questions on that document any further. Mr. Challey asked you about Ms. Walker's deposition that was conducted last week, and he specifically mentioned testimony Ms. Walker gave about a document that she sent regarding her testimony. I'd like to pull up a portion of Ms. Walker's deposition where she's referring to that document, and it's on page 107, line 25. Page 104, line 25. I'd like to read from this quote or question. It's hard. It's hard to. It says 2 a.m. to 4 a.m. Eastern Time, so I don't know what the timestamp indicates. Answer: May 26th was when my husband was at the worst that he could be, so I doubt I went. I was spending the night at home and driving back and forth to the hospital every day to be with him. And I'll turn forward now to page 107 of this document, where she refers to the exhibit that Mr. Challey showed you. Line 6. Were you being truthful with Mr. Kokums when he said that you were very happy with your testimony? No. I mean, I had confidence that he would make sure it was done right. I didn't have time to deal with anything to do with work. So when you said I'm very happy with it, you were lying to Mr. Kokums. Answer: No, I wasn't lying. I was just expressing my confidence in him. Mr. Jones, do you view this testimony as supporting your position regarding Ms. Walker's testimony about her 2015 testimony?
It sure seems to me.
Mr. Jones, in conclusion, you were asked by Mr. Challey about why you didn't tell certain things to the commission in 2015. Was it you or Mr. Byrne who testified to the commission in 2015?
I did not testify to the commission in 2015. I think Mr. Byrne did.
Thank you, Mr. Jones. No further questions, Mr. Chairman.
Thank you. Okay, now we're open for recross from any of the parties. Mr. Guile, anyone else? Okay. Step right up.
Okay, Mr. Jones, just for the record, John Challey, representing SCENG. I just have a couple of quick questions for you. Mr. Cox handed you a May 16, 2018 AIR, right? You recall that?
You're speaking of AIR 132?
No. The AIR that was issued in 2018 that sought specifically the Bechtel report.
Oh, okay.
So ORS clearly, as that document conveys, knew how to issue a request that sought specifically the Bechtel report, right?
We certainly did when we knew the Bechtel report existed, yes, sir.
And it knew how to issue an AIR that referenced Bechtel specifically. It did it in 2018, and SE and G objected to it on the basis of privilege at that point. And that all consistent with your understanding of this document?
Yes.
And I believe you said that you thought litigation was prohibited under the EPC amendment. Is that right?
That's my understanding. The litigation, I think litigation could have occurred subsequent to the completion of the project, but that was also cast aside by bankruptcy.
There was a dispute resolution mechanism in the agreement, was there not?
There was.
That disputes between the parties, that is the consortium and the owners, could be presented to the dispute resolution board. Isn't that right?
Yes.
And in fact, that happened before Westinghouse declared bankruptcy, did it not?
Yes, there were several disputes taken to this dispute resolution board.
Okay. And then, of course, as you said, not only was there that sort of dispute that could be created, there was the potential for disputes following the conclusion of the project, right?
Potentially.
Those are all forms of litigation that could exist, notwithstanding what you're saying you recall about the amendment not allowing for litigation.
Not after May 16th, 2018, sir. There was nothing that existed that that would have permitted litigation then.
Because of the bankruptcy?
Correct.
Okay. Now, the last point I want to cover briefly is performance factors. You understood, and you understand today, that performance factor, when used for purposes of determining an estimate at completion, is just a projection of future performance. Isn't that right?
As all estimates.
Right. So it is nothing more than an estimate of what one might expect to come into the future. Correct?
Correct, as are all estimates.
Right. And you understood that Westinghouse had used a performance factor of 115 for its analysis as presented to the Commission in 2015, correct?
Yes.
And you understood and you understand now that that projected performance factor was based on a contractual commitment between Westinghouse and the owners, one that was supported by liquidated damages that the owners would be entitled to if it weren't met, and one that helped Westinghouse meet its market objective of being able to construct nuclear reactors. So all of those things fed into Westinghouse's commitment to meet a 1.15 to-go performance factor, correct?
You packed too much into that question. You're going to have to divide it up a little bit.
You understood in 2014 and 2015 that Westinghouse had a contractual commitment to meet a estimate at completion, and that if they didn't meet that estimate at completion, there was the potential for liquidated damages under the contract.
Yes.
Okay. And you also understood that Westinghouse was marketing itself as capable of constructing these nuclear reactors in the United States, and their failure to meet their commitments would negatively impact their ability to sell this technology to other utilities in the United States, right?
Yeah, I think I had a general understanding based on industry wide knowledge, not specific to this project, but that Westinghouse wanted to sell more nuclear plants.
And you understood that all of that factored into their commitment to meet a 1.15 to-go performance factor, correct?
I mean, there's a lot of things that factored into that. I guess you could say yes. The desire to do more nuclear plants was one of the things that they hoped to demonstrate that they could achieve good results on VC Summer.
Okay. And the alternative EAC that you're now relying on, the EAC that you say is developed by SCE&G, had no contractual commitment associated with it and no liquidated damages associated with it, correct?
And those did not even exist at the time the EAC you're talking about.
Well,
There were no contractual commitments at that time that addressed the issues that you're talking about. Those came later.
Okay, so you understood that at least as to SCANA's SCE&G's EAC team, that their projection was prepared by a handful of SCE&G employees with none of the same ramifications that was attendant to the consortium's commitment to meet a 1.15 productivity factor in the future, right?
You're equating something that doesn't need to be equated, and that is what should have been done with the EAC estimate is they should have gone back to Westinghouse and had them defend their estimate and come up with a unified construction estimate that both the consortium and SCE&G agreed with based on the input from the EAC. It is not the total estimate for the project. It would have been a basis for discussion, and it would have been a basis for discussion with ORS also, and we should have been involved in that. That's what I've always contended.
Okay, so you saw Mr. Cox showed to you a copy of this particular presentation, this EAC review team presentation. That's right?
Yes.
And is this the review team that you believe was led by Carlette Walker?
As I have stated, Ms. Walker said she led the team. That's why I made that statement.
Okay, but her name's not on the presentation at all, is it?
It would not, in the current situation, or the situation she was in at the time, it doesn't surprise me that her name is not there, no.
Okay, but her name's not on the presentation, is it, Mr. Jones?
It is not there.
Okay. All right, do you know who of these individuals listed on this page, Ken Brown, Margaret Felkel, Kevin Cocombs, Sherry Wicker, and Kyle Young, can you identify whether any of those individuals have ever been involved in a nuclear construction project other than BC Summer?
I cannot, I don't know their entire background, so no, I cannot identify that.
But you know that in 2014, Westinghouse was involved in the construction of nuclear reactors in various different locations, correct?
That Westinghouse was involved in construction? Yes.
Correct. And you also know from this presentation that this very review team, the review team that you're saying concluded a different productivity factor would be appropriate, recommended that the owners hold the consortium to the 1.15 productivity factor, correct?
It's odd to me that you would impeach your own people, but if that's what you're saying.
No, I'm saying that this team you're relying on, said that the owners should hold the consortium to the 1.15 productivity factor.
Well, let's pull a string on that a little bit. You brag on Westinghouse. You brag on a company that never got a schedule right in the whole history of the project, and I think that played a lot of influence on the conclusion that these people came to. Yes, they had been involved in lots of nuclear projects. Had they ever completed the construction of one? No. Did they have a schedule that SCE&G believed in? No. Did we know that at the time? No.
You said you had no confidence in the schedule at the time, Mr. Jones. We went through that in the 2015 testimony that you prepared. Isn't that correct?
No, not for 2015. What I said was I believed at that time that they could make the schedule within the 18-month window allowed by the BLRA.
You wrote a note to Duke Scott in 2015. Paragraph 3 of that note, the very first line said, "I have no confidence in the schedules." Do you recall that?
Yes, I had no confidence that they would meet the specific dates that we're talking about.
Okay, let's just go to page 3 of this document, Dan, and this is the same page that Mr. Cox showed to you. Mr. Cox did not have you read the second bullet where the EAC team recommends holding CB&I accountable to this PF, which was the projected PF that Westinghouse had committed to, 1.15. See that?
Okay.
Okay, so you understand that even this EAC team that you are relying on recommended that the owners hold the consortium to the 1.15 PF, not the higher PF, correct?
That's not how I interpret this. I interpret this to say we're only going to pay them based on that.
It says recommends holding CB&I accountable to this PF, doesn't it?
And it says only paying them to this level. To me, that's the key thing, that you only pay them based on what they said they're going to do. That doesn't mean that you believe that they're going to achieve it. It means you only pay them to that level.
Okay, that's all I have. Thank you.
Thank you. Okay, so we conclude our recross. Mr. Jones, you may step down, subject to recall.
Hallelujah, sir.
Yes, sir. Okay. Well, there's a couple of things I've learned today. Don't have anything to do with the case, but a couple of questions means a lot, and a few questions means about 50 to 100 with a bunch of exhibits. So, new terminology for me every day. Okay, ORS, next witness.
For the record, and as requested by the chairman of the hearing office, my name is Stephen Ham with ORS. We call as our first witness at this point Anthony James. May I proceed, Mr. Chairman? Will you please state your... Are you ready?
Cut your microphone on, Mr. James. Make sure it's got the red light on. There you go.
Okay.
Get close.
Jones left a mess up here.
Tell me when you're ready, Mr. James. We can proceed timely for the commission.
Very good.
Ready? All right. Would you please state your full name and occupation for the record?
My name is Anthony James. I am the Director of Energy Policy for the Office of Regulatory Staff.
Briefly outline your educational background to the commission, please.
Yes, I have a bachelor's degree in engineering from the University of South Carolina.
Thank you.
And I have a master's degree also from USC in Earth and Environmental Resource Management. I'm a licensed engineer registered in the state of South Carolina.
Thank you. Are you the same Anthony James who pre-filed 19 pages of direct testimony and 5 exhibits in docket number 2017-370E on September the 24th, 2018?
Yes, I am.
If I ask you the same questions contained in that testimony, would your answers be the same today?
Yes, they would.
All right. Mr. Chairman, the Office of Regulatory Staff asked that Mr. James' direct testimony be entered into the records as given orally from the stand, and that his exhibits 1 through 5 be marked as a composite exhibit and entered into the record as the next hearing exhibit, which according to my notes, it's I think 31 or 32.
Okay, Mr. James, direct pre-filed testimony will be entered into the record as though given orally from the stand. And his exhibits will be listed as a composite exhibit number 32.
Thank you, Mr. Chairman. Mr. James, are you the same Anthony James who pre-filed 7 pages of surrebuttal testimony in dockets number 2017-370E on October the 29th, 2018?
Yes, I am.
And if I were to ask you the questions contained therein, would your answers be the same?
Yes, they would.
Mr. Chairman, I would add the Office of Regulatory Staff asked that Mr. James' surrebuttal testimony be entered into the records if given orally from the stand.
Mr. James, surrebuttal testimony will be entered into the record as given orally from the stand.
And consistent, Mr. Chairman and hearing officer, consistent with the ruling in late October involving placing all of the ORS testimony in all 3 dockets, I need to clean up the record on one matter. Mr. James, are you the same Anthony James who pre-filed 7 pages of direct testimony in Docket 2017-305E on August the 14th, 2018?
Yes, I am.
And if I ask you the questions contained therein, would your answers be the same?
Yes, they would.
I would ask that that pre-filed testimony, it's consistent with the order issued by the hearing officer during the course of preparing for this hearing, be placed into the record as if given orally from the stand, Mr. Chairman.
It will be read into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. James, have you prepared a summary of your pre-filed testimonies?
Yes, I have.
Would you please share that summary with the commission and the parties, please?
Certainly.
Mr. Chairman, again, consistent with the ruling that was issued last week, you asked us we had pre-filed some testimony that contained redacted areas, and you asked us to file a clean copy of that testimony, and that is what our ORS staff member is doing right now, consistent with the commission's order.
Great, thank you.
Yes, sir. All right.
Good afternoon, Mr. Chairman and Commissioners. My direct testimony introduces ORS witnesses that will testify on various matters regarding SCNG's decision to abandon construction of VC Summer Nuclear Units 2 and 3, provides an overview of SCNG's and Dominion Energy's request, summarizes ORS's proposal, and provides an overview of ORS's monitoring activities. ORS will present several witnesses. They are internal and external subject matter experts that will address various topics, including prudency, the results of an economic analysis of the project, accounting adjustments and findings, return on equity, and bill impacts. SCE&G and Dominion are seeking 1. Approval of the proposed merger between Dominion Energy, Inc. and SCE&G's parent company, SCANA. 2. A prudency determination regarding SCE&G's decision to abandon the units. And 3. Approval to recover costs associated with the abandoned units. As part of their request, SCE&G and Dominion offer 3 proposals. 1. The Customer Benefits Plan, which includes a request to recover approximately a project cost of $3.3 billion over 20 years at a return on equity of 10.25%, prudency determinations, and other accounting and rate-making treatments. 2. If the merger does not close, SCE&G requests the PSC approve the No Merger Benefits Plan, which includes a request to recover approximately $3.1 billion in project costs over 50 years, and a return on equity of 10.25%, prudency determinations, and other accounting and rate-making treatments. 3. If the merger does not close and the PSC does not approve the No Merger Benefits Plan, SCE&G requests the PSC approve the base request. The base request includes a request to recover approximately $3.6 billion in project costs over 50 years at a return on equity of 10.25%, prudency determinations, and other accounting and rate-making treatments. ORS's proposal. ORS offers the Optimal Ratepayer Benefits Plan, or the Optimal Plan. The Optimal Plan provides a net reduction of approximately $193 million and $160 million in the years of 2019 and 2020, respectively. Under ORS's Optimal Plan, the average monthly bill for a residential customer will decrease by approximately $30.93. And that's going from $147.70 down to $116.77 in the first year. In the second year, a residential customer's bill will be further reduced to approximately $114.57. The Baseload Review Act establishes ORS's ongoing monitoring responsibilities. ORS's duties include several activities such as auditing capital cost expenditures and reviewing invoices, performing weekly site reviews of construction documents, attending on-site meetings with project managers, attending NRC public meetings, visiting vendor fabrication facilities, and providing written reports in response to SC&G's required quarterly reports. My surrebuttal testimony responds to Dr. Petrunik, Ms. Griffin, and Mr. Addison. I respond to Dr. Petrunik's statement that the Bechtel schedule was unreliable. Ms. Griffin's statement regarding incentive compensation, and Mr. Addison's statement regarding ORS's application of the definition of prudency in Act 258. I disagree with Dr. Petrunik's statement that the Bechtel schedule analysis is unreliable. On October 19, 2018, ORS deposed Mr. Ty Troutman of Bechtel. Mr. Troutman was assigned to oversee the Bechtel assessment and has over 25 years of experience building new nuclear power plants and operating them. At the time of Bechtel's assessment, Mr. Troutman was the general manager for nuclear power worldwide and president of Bechtel. His testimony soundly debunks Dr. Petrunik's claim that Bechtel had limited access to information and produced an unreliable schedule. Mr. Troutman states, "We ultimately got everything we needed to do the assessment we performed." Mr. Troutman also states that the schedule analysis is essential to performing an assessment. Mr. Troutman states, analyzing the schedule was needed to feed as an underpinning either the foundation or the actual fabric that holds together the rest of the assessment. I also disagree with Dr. Petrunik's statement that SNG set a tone of culture of openness and communications and undertaking its role as owner of the project. On September 25, 2018, ORS deposed Mr. Kenneth Brown, a member of SC&G's business and finance group working on the project. During his testimony, Mr. Brown states that before attending a meeting with ORS related to SC&G's 2015 request to update the project schedule and budget, he was provided talking points, and he was instructed what to tell ORS. The talking points specifically excluded Mr. Brown's belief that the cost to complete the project being presented to ORS was unattainable. Certainly, SC&G's behavior does not reflect a culture of openness. I address SC&G's regulatory responsibility to inform the Commission of the Bechtel assessment. This responsibility is found in statutory requirements as well as in the initial baseload review order approving the construction of the two nuclear units. In order number 2009-104A, SC&G is required to provide quarterly reports to the PSC and provide a yearly status report. Regarding the yearly status report, order number 2009-104A states, in order that the public and the Commission remain informed about the project, the company will provide the Commission with a yearly status report on its progress and other significant developments. Pursuant to Section 5833-277A, SC&G is required to file reports with ORS quarterly until the plant begins operation. The Baseload Review Act requires that these quarterly reports must contain the following information. 1, progress of construction of the plant. 2, updated construction schedules. 3, schedules of the capital costs incurred, including updates to the information required by Section 5833-270B5. And 4, updated schedules of anticipated capital costs. And 5, other information as the Office of Regulatory Staff may require. Section 5833-280B requires the revised rates filing shall include most recent monitoring reports filed under Section 5833-277A updated to reflect information current as of the date specified in the filing. I also address ORS's duties, which are found in Section 5833-277B, and it includes ongoing monitoring of the construction of the plant and expenditure through review and audit of SC&G's quarterly reports. Under this article, and shall have the right to inspect the books and records, the plant, and the physical production of construction upon reasonable notice to the utility. SC&G failed to advise the Commission that Bechtel had been hired to conduct an assessment of the project. In fact, in no document filed with the Commission or otherwise available in the public domain is there any discussion regarding Bechtel's assessment of the project. There is absolutely no mention of Bechtel's on-site activities, Bechtel's findings and recommendations, and most importantly, Bechtel's analysis of the schedule, which produced project completion dates, which were years beyond the completion dates SC&G provided the Commission. As outlined above, SC&G had the regulatory responsibility to share the status information regarding the project with the Commission. This responsibility resides with SCE&G and SCE&G alone. Based on the information received by ORS through discovery, we now know the following. In September 2014, SC&G was seeking assistance with evaluating the construction schedule and the project status, and ultimately hired Bechtel. An attorney was hired to conceal the retention of Bechtel and Bechtel's reports. And SC&G went to extremes to prevent the release of the Bechtel report, which included a schedule analysis. I also present direct testimony in Docket 2017-305E, where an ORS requests rate relief for South Carolina ratepayers, SC&G ratepayers. The issues in Docket number 27305E are incorporated by reference into my direct and surrebuttal testimony in this docket. That's 27370E. And this concludes my summary.
Thank you, Mr. James. Mr. Chairman, members of the Commission, Mr. James is available for examination by the parties in the Commission.
And that will happen after a short break.
Thank you. Thank you, Mr. Chairman.
We'll go about 10 minutes.
Almost done.